At Demmery Law, we have the pleasure of representing both citizens and non-citizens in legal actions. We regularly have clients who are concerned that a DUI conviction may result in deportation. This video addresses the potential immigration consequences to a non-citizen for a DUI conviction in Florida. Florida law requires a trial judge to inform a defendant that if they plead guilty or nolo contendere and are not a United States citizen, the plea may subject the non-citizen defendant to deportation pursuant to the laws and regulations governing the United States Immigration and Naturalization Service. This rule is mandatory and cannot be satisfied merely by the defendant signing a waiver form or having the written plea agreement read to them by their trial counsel. A guilty plea will not be vacated on the sole ground that a non-citizen defendant may have been affirmatively misinformed about deportation as a collateral consequence of pleading guilty. However, a plea entered without advice of deportation consequences, rather than an actual threat of deportation, can constitute prejudice sufficient to support a motion to vacate. If there is a failure to provide this warning, there may be grounds for post-conviction relief if the defendant can demonstrate prejudice by omission. However, if the defendant is being deported for reasons other than the DUI conviction, such as illegal entry, the plea may not be vacated. Additionally, a DUI conviction may have an impact on a non-citizen's immigration status, particularly if the offense is classified as an aggravated felony under federal law. A DUI conviction in Florida is not typically considered a crime involving moral turpitude, which are often the types of offenses that result in deportation. However, the government can consider a DUI a crime involving moral turpitude if it involves reckless driving or causing serious bodily injury or death. In addition to crimes of moral turpitude and aggravated felonies, multiple DUI convictions can indicate a disregard for the law and public safety, which can trigger deportation proceedings in Florida. In addition, a DUI conviction can be compounded by other criminal charges, such as driving without a license, drug possession, or child endangerment, which can also trigger deportation proceedings. In sum, a DUI charge can lead to deportation for undocumented immigrants, especially if it is coupled with other criminal offenses or if the individual has prior convictions. Tanner Demmery of Demmery Law is a former prosecutor and public defender who has nearly 20 years of trial experience in Florida. If you or someone you know needs help, contact Demmery Law at 954-224-0577 or email Tanner at demmerylaw.com. Keep Demmery in your memory.